top. Has anybody gotten a call from the police news reaching out to real estate agents wanting to work with like police officers?
Yes, I get it all the time.
God,
I just got one like a minute ago.
Okay.
It's always from a Colorado number.
Yep.
Okay.
So just a scam.
Yeah, we love a good scam. Always thought we maybe had a lead. Oops.
Yeah, I know that's. Okay, so back to what I was saying before I paused us to hit the record button. So assessments, if the city were to come in and say, hey, we want to put sidewalks in, it's going to be $100,000 project. Obviously, I'm all speaking hypothetical numbers here. It's going to cost each of you 10 grand. Homeowner says, well, I don't have 10 grand to pay you. And the city says, no problem. We'll just go ahead and divide that into monthly payments for X amount of years, and it'll just become part of your taxes. Another example of that is I live in, can you guys see my screen still?
No, we can see your face though.
Okay. That's what I thought. Like, I'm on the struggle bus this morning with Zoom. Here we go. I couldn't see any of you. I was just, there we go.
Yay, now we can see it.
Okay. Okay, there we go. So my home in particular, we're on a well, which I actually really like because we use a lot of water and I don't have a water bill, but the city has been trying to, for years, push through us getting hooked up to city water, which is going to cost a significant amount of money if they choose to do that, which would be my responsibility. And if I didn't have the money to pay for it up front, which I probably wouldn't because it's a pretty expensive project, then they're going to assess that onto my taxes. Now, Alexa, to your point on HOAs, that's a little bit different because it's not a city assessment through the city. It's an HOA assessment. I'm going to be 100% honest with you. That never makes a lot of sense to me either, because I feel like the whole purpose of the HOA fees is that you're supposed to be paying into the HOA, right, for them to build a reserve to cover things like repairs that are needed to be done. Sometimes I think things happen or building repairs happen that they weren't anticipating and are quite expensive. Like, I don't know if any of you have shown or saw the condos downtown. There's a couple of them that have like $700 a month assessments on them because like the whole exterior had to be done, redone. So that's separate. That's an assessment that the HOA is putting on the property for work that was done to the common areas of the condo association. Does that make sense?
Thank you for that clarity. I guess I was just kind of like bubble brained there for a second and didn't put two and two together that they were separate. I was like, duh, yeah. But now it's like a duh moment. Yeah. Thank you, Cass.
And in here, like I always just check seller to pay, because that's in my buyer's best interest. Sometimes you'll see in the purchase agreement that the agent specifically outlines that the buyer is to absorb or take on that. So these different boxes that you check, it doesn't happen very often. So my best advice or rule of thumb for these boxes are just going to be to always check seller. And if you ever run into a situation where you're writing an offer on one that they want the buyer to assume them, give me a call and we can talk through how to check these boxes appropriately. Even very seasoned agents get confused on this. And to be honest with you, I have to see what the assessment is, see what the agent's notes are, and then I reread through this and determine which boxes need to be checked. So I think for today's purposes, again, I would just always check seller shall pay. And if you run into that situation, give me a call and we'll discuss otherwise. 239, I always check has not, but I've had people say, well, Cassie, but how do we know if the seller has received that? Well, two things. One, I feel like if I check has not and the seller has received it, it's their responsibility to revise the purchase agreement and check has. But if you actually open up the seller's disclosures, there is a question in here that matches this, asking the seller if they've received something from the city. So you can always go to the seller's disclosure, review what the seller has checked, and then mark that here.
Cool. Okay. Thank you.
Yep. All right. Next section is additional provisions, which Is this contingent upon a previously executed purchase agreement? Typically, that's always going to be is not. We have 2 agents on the team right now who actually this box is checked is. And then you would mark when the purchase agreement had been executed and when the signed cancellation will be received by. So generally, I would always recommend, like, why don't you just wait until that signed cancellation, especially if you're representing the buyer, right? Like, why don't we just wait till you get that signed cancellation? Because what if that signed cancellation takes like 3, 4, 5 days? In the meantime, another property list that they actually, absolutely fall in love with, and now they're tied down to this. In these 2 situations where the agents on the team actually have this going on right now, is that they have listings that are under contract with buyers who had homes to sell, and they got backup offers, and they're trying to lock that backup offer in through a signed purchase agreement while they call the contingency on the other property. They don't want to end up in a situation where they have 0 offers, right? By calling the first buyer's contingency and taking the time to get that called. And then in the meantime, the second buyer who is interested found another property, and now you have no buyers. Does that make sense?
No, can you re-explain that one?
Yeah, I'm confused too. I guess I'm confused on 252 about the cancellation.
Okay. So we have an agent on the team who has a listing.
Okay.
That listing has a signed purchase agreement. That buyer is contingent upon their home selling. Okay. So in came the home sale contingency. I think we spent quite a bit of time talking about that last week. Per that addendum, we as a listing agent and seller called the current buyer's contingency and said, hey, we've got another offer in. I'm calling your contingency, which then per the purchase agreement in this particular case, they had 3 days to remove that home sale contingency, meaning they have 3 days to provide us a fully written purchase agreement that has no contingencies other than financing. So we now have a second offer that came in that we negotiated through that offer with them and had them sign a purchase agreement that agrees that, hey, this purchase agreement is not going to be valid unless we can cancel this other one out.
Okay, I got it now.
Does that make sense?
Yeah, that makes sense.
Okay, so then this line is giving us X amount of days to obtain that signed cancellation. In this case, the buyers have 3 days to remove the home sale contingency. If they don't do that by midnight tomorrow, we're able to sign a cancellation with them and move on with these buyers.
Cool. That one's kind of cool.
This is technically the second offer, like the backup offer.
Yes,
okay.
Correct.
Got it.
Yeah. All right. Next is deeds. You have warranty deed, personal representative's deed, contract for deed, trustee's deed, and other. Warranty deed is the best kind of deed. It's the overall giving, seller. Let me actually just do this. I just had, where am I? Oh, I'm going to have to close out of this. I'm just going to open this up. It's easier. I get a lot of questions on deeds. Typically, you're always going to check warranty deed, but every once in a while, you'll get in agent remarks, it'll say that, this is the type of deed, make sure that you check it. So I get questions on that quite often. So I had marketing create this for me. I just haven't posted it yet. So basically a deed is the written document that's transferring title to land from one person to another. So the different types of deeds you have. Contract for deed, are you guys all familiar with what that means?
Yeah.
It's where the buyer's the seller's pretty much financing it. That's not done a lot. Deed in lieu of foreclosure. this right now is not done a lot either. So I'm not going to spend a whole lot of time. I want to focus more on the ones that are actually in the purchase agreement. So deed of trust is a trust deed or similar to a mortgage. Title is transferred to a trustee, which usually a trust or title company that holds the real property as security for the buyer's loan. At the time that the loan is paid in full, title is transferred to the borrower. The only powers that the trustee has is the power of sale if the borrower defaults. Okay, these are ones more I wanted to focus on. Personal representatives deeds is an estate planning tool that names the executor of the estate with powers to transfer title for real estate. It is then the personal representative's duty to transfer the title of the deceased real estate owner to a new party or buyer. So if it's a personal representative's deed, that's basically someone who, you know, their mom, their brother, their aunt, whomever it was, passed away. They now acquired the property and have the right to sell the property. And so they're transferring you a personal representative's deed because they're basically just saying, hey, I only know what happened on title in the short amount of time that I have owned the property. I can't give you guarantees on anything previous to the time that I took ownership of this. That's why I always tell people that's the purpose of obtaining title insurance, right? If you're obtaining a mortgage, then title insurance for the mortgage company is required. And it costs like $700 or $800 for buyers to get title insurance. But that's why that's so important, because it protects a buyer against anybody coming along the way later and saying that they have a vested interest or ownership in the property.
Okay, I have a question.
Yeah.
Hypothetical. So I love your little story that you say when someone dies and they have to like figure out the transaction from there.
Yeah.
So if the original PA states that it's like a warranty deed or whatever, but seller dies, would there have to be an amendment that says personal representative's deed for now because the seller can't transfer the property because they're dead?
Well, I think that's a whole nother rabbit hole for us to go down, right? Like, has it happened where sellers have died during the transaction? Yeah, it just doesn't happen very frequently. I think we would have to cross that bridge when we get there. It depends on who's taking it over, because if a homeowner was in ownership of the property with a spouse, and they're still a surviving spouse, then a warranty deed can still be transferred.
Right. Okay.
This would be in the instance that it's like a solo owner, or I suppose you could have two owners who both passed away unexpectedly. It would just be anytime that someone basically gets a power of attorney to sell the property.
Okay.
Warranty deed is the deed containing express covenants as to the good title and right to possession. And trustee's deed is the deed given by the trustee under a deed of trust when the secured property is sold under power of sale. So many people put their properties in trusts. And that's when a trustee's deed is issued. So I'm going to post this and you guys can read through it. I'm going to get it put in Slack and it's going to be put on agent resources. I would say the most common, that you're going to be dealing with. Well, then there's the quick claim deed where it's a form deed containing no warranties and conveying the current right, title, and interest of the grantor. I guess an easy way for me to explain this is my sister-in-law just recently went through a divorce. Her husband got the house in the sale. She signed on a quick claim deed to remove herself from title. So she no longer has any rights to the property. Does that make sense?
Yeah, I love your little stories. Anytime you have those, they help everything. So just keep those coming, Cass.
Good. The interesting thing about that is she quit claimed the deed to him and it removed her off title. It did not remove her from her responsibility to the mortgage. So just because you remove yourself from title doesn't mean you're still not responsible for the mortgage. In their case, he refinanced the property and took her off. So she's now removed from everything. But they're two separate things. Just as a FYI. I feel like quick claim deeds are most often used in divorce situations, to be honest with you.
So is the only way that you can get off the mortgage just to refinance? I'm just curious because my parents aren't together and this might be something we come across.
Yeah. I mean, pay it off, obviously. You could certainly make a phone call into the lender to find out, but they're very likely not going to release someone who's responsible for it off. Why would they? Like, they're going to be like, well, we don't care that you got divorced. You promised us you were going to pay this back, whether you're living in the property or not. Does that make sense?
Yeah, I have one funny question.
Yeah, that makes sense.
So pretend that they had an interest rate at like 2% and then they had to refinance and it's like higher rates now and they can't afford that new mortgage. Do they just not have to, like, what do they do in that circumstance if they can't refinance?
So that's interesting too, because my sister-in-law who just got divorced, that was his second divorce. And he had built this house with his first wife. And at the time that they got divorced, his company was, it was kind of during the last housing market crash and recession, 2008, 2009 timeframe. And he didn't qualify to refinance. But he knew that at the time of his divorce, and in the divorce decree put that he had X amount of years to basically get his shit together and get it refinanced, which he was able to do. Now, in the event that he wouldn't have been able to do that, what would happen? I have no idea, right? She could probably take him back to court because he's out of what was agreed to in the divorce decree. But if you really went into a judge and said, what am I supposed to do here? I'm making the payments, but I don't qualify to refinance or whatever the case may be. I suppose a judge could hammer down and require you to sell it.
True.
I mean, that would be kind of a jerk move, but you're right, Alexa. And that's what sucks is because the last couple of years, interest rates were so low. So I don't have all the answers to that. That's where that's a little above and beyond our fiduciary duties as agents. And at a point that you start recommending that they contact an attorney.
Okay.
I mean, it's good to have the knowledge yourself, but guiding buyers on it or even sellers on it, I would advise them to contact an attorney.
Yeah, once it gets gray and if you don't know it or not sure on something, I'm like, yeah, sorry, bro. You got to get an attorney at that point. Mm-hmm. We're not sure. But yeah. Thank you, Cass. I love testing your brain too. It's so fun. Okay.
Okay. Next section is possession immediately after closing or other. I personally hate anything other immediately after closing. And the reason being is the liability that comes with that. A few stories here. Oh, Colin, are you trying to enter again? So it always seems like everything's going to be great, right? Buyer and seller are happy. The whole transaction went great. But the seller now needs a little bit more time to get out for one reason or another. Or maybe they're advertising that right from the jump that seller needs 30 days post-closing to get out of the house for whatever reason. There's a variety of reasons that this request is made.
Yeah, I will tell.
Colin.
Sorry, Kassie.
No problem.
Wait, I have a question, Cass, with that one too. So like my last one, what happened is it said immediately after closing and went to close the night of 8:44 p.m. rolls around and sellers accidentally left those keys inside, remember?
Yeah.
So because it says immediately after closing, would it be the seller's responsibility to go get that key and then provide it to those buyers if they weren't able to get into that property?
It would have been the listing agent's responsibility is to deliver the keys. Yeah.
Okay. So I could have, we figured it out, but I could have said, hey, this is their first night in their home. They would really appreciate it. We would really appreciate you going over to get that key and delivering it to them.
Yeah, I mean, absolutely. Because in that case, Alexa, so for those of you who are on the phone, Alexa had a closing that was just a couple blocks from me. So I did the final walkthrough with her. I had assumed, and I guess it was a bad assumption on my part, that and I was going to tell Alexa, but things kind of went sideways for a couple different reasons on that one, is to give the buyers the lockbox number. You have to do this with the listing agent's permission. So back in the day, all parties used to go to closing together. You had the buyers on one side of the table, the sellers on the other side of the table, their respective agents and their respective title representation. Okay. And what was nice about this is all the paperwork was signed. And at the end, the title folks went in the back room to make all their copies for their clients. And then you as the agents and buyers and sellers exchanged keys, any information about the house. Hey, what's the garage code? You know, do I have to tap the, what is it? Whatever. If there's any quirks about the house, right? They kind of exchanged all this information. Then once COVID hit, we couldn't have all these people in the room anymore. So that's actually what started what probably a lot of you know right now as just a typical closing, which is that sellers pre-sign and buyers, you know, sign on the date of closing, and buyers and sellers might not ever meet. We got a little off track there. Did I answer your question?
Yeah, you answered mine. Yeah.
Okay. So back to immediately after closing and then other, especially in recent years where seller has had all control in transactions, because basically they were like, if you don't like what I'm about to do, then I'll find a buyer who's willing to accept it. I want 3 days after closing to be able to move out of my house, because closing day can be stressful for sellers, right? Like let's say you have closing at 11 o'clock on your home sale and you have closing at 1 o'clock on your new home. You can't get into your new home until you've closed on it. Meanwhile, you've got to be out of your old home 2 hours ahead of that. Here's the problem is when other is checked and you have post-closing occupancy with the seller, typically there's an, if it's longer than just a couple days here, you really should get like a rent back agreement signed. But the problem is you've done your final walkthrough. Everything looks great. Seller has 3 additional days to move out of the property. Buyers show up on that 3rd day, and the seller's moving company or the sellers themselves, you know, dropped the couch as they were moving it down the stairs and there's a hole in the wall. Or they didn't leave it clean. Another one we experienced is a lady was given 30 days to move out because I think that's when she needed to close on this property before she could close on the next one. Well, in that time frame, her new home sale fell apart. She had nowhere to go. She refused to leave the property. She changed all the locks on the doors. She had 3 dogs that she started letting them use the house as their personal bathroom. She wouldn't respond to anybody. It was a nightmare of a situation that the new buyers ultimately had to hire an attorney and go through an eviction process with her.
Oh my God. Okay. Wow.
And you know, that stinks because like, what if you as a buyer didn't have the money to hire an attorney to go through this costly thing? And then that was also pre-2020 before the like rental memorandums or whatever you call it, you know, during that time period, you couldn't evict as a landlord. So
then what'd you do?
Well, that was a whole situation with the court. I mean, nobody could evict during that time frame. And that I think that put a lot of landlords in a tough spot because there was people who just stopped paying their rent. And obviously the landlord, unless they owned it free and clear, still had bills to pay, but they weren't getting cash flow in from renters to cover that. You know, I think that that's a whole other story, but my point and purpose right here is just to say, at all costs, avoid anything but immediately after closing for possession. If you run into a situation where it has to be anything other than that, let's discuss it. Give me a call. It's just like you can see, so many things happen, right? So many variety of things can happen. Okay, bye, Dylan. Unless he already left. So many things that can, you know, the other thing is, okay, now it's post-closing. Sellers still live there. The furnace goes out. Who's responsible for it?
I don't know.
I mean, technically the buyer owns it, right? Buyer owns the property, but guess what happens? They're now upset and pissed off because they feel that the seller probably did something to cause the furnace to not work. And now they want the seller to be responsible for it. And the seller's saying, well, hey, it's not my responsibility. You own the property now. Bad luck on your part. So these are some of all of the things that become problematic and potential issues with having a seller occupy the property post-closing. I can tell you, I've never seen one of these go well, ever. Okay. Something always happens. And what's funny is when agents call me and they say, hey, we want to do a post-closing occupancy for however much time, you know, the transaction's gone really great. Buyer and seller are awesome. I don't foresee this being problematic. And I'm like, okay, I'm just here to warn you that I never see these go well. And then I'll get a call a couple days after closing. Something bad happened. And now we're talking through that. So again, I mean, I guess some could argue sometimes it's unavoidable. I disagree. I feel like if anything comes up on the seller's behalf that they can't provide possession immediately after closing, then we have closing be for the day that they can.
Okay.
All right. So the rest of this the rest of this is basically just going through explanation of what things in the purchase agreement are. Linked devices. So this is just talking about anything that's linked to the property and whether it stays or goes, like ring doorbells are something that should be staying with the property unless otherwise specifically noted in the PA. I had another issue once where seller had speakers hardwired in the house, right? So the TV was mounted to the wall, and then there was wiring that went through the ceiling and then came out the ceiling, and speakers were hooked up to it, but the speakers were not mounted to the wall. The sellers took the speakers and an entryway mirror in this same one, as odd as this was. The buyer's agent was freaking out because the sellers took the speakers. And I argued that the house was hardwired for speakers. It didn't mean that the speakers conveyed because they weren't attached to the property. They were sitting on shelves. But that same agent also, the buyers had this huge mirror in the entryway. That was, I mean, think about if you had a picture hanging in your entryway of your family. And this is what I ended up telling the other agent who was squawking about it. Cause she's like, everything attached, bathroom mirrors stay, this entryway mirror should stay. And I said, well, what if that entryway mirror would have been a picture of the family? Would they have wanted that to stay? And, you know, that kind of shut the agent up. But linked devices, especially if they are attached to the property, convey with the property. Next section.
One last thing, Cass.
Yeah.
So I was reading my little real estate book yesterday, just learning a little bit more and like just everything. It's the Maria method and its method of attachment, but additionally, what its intended use was for before. So because its intended use was strung through those wires in the like walls, and then the item was placed, because the method of attachment was meant to literally go through the walls and connect to this item, that would mean it's basically connected as a fixture at that point.
Oh, interesting.
Crazy stuff.
Yeah. See, and in this case, that other agent didn't argue with me because I was like, well, they weren't, you know, and that could have changed too, Alexa. A lot of obviously things have changed since I got licensed in 1940s. I'm just kidding. But you know, things change and evolve over time, because I mean, back when I was licensed, we didn't have things like ring doorbells and things like that. So that's good to know. I ended up winning that fight with that agent, but nonetheless. Proration. So this next section is just talking about how things are prorated. City water, city sewer, electricity, natural gas should be, so this is what I do want to point out here, and you don't see this often, but every once in a while you will, a property that's heated through natural gas. So there's a tank at the property that's filled, and it states here, buyer shall pay seller for remaining gallons of fuel, oil, or liquid petroleum gas on the day of closing. at the rate of the last fill by seller. So if you have a buyer, they will get a proration for this on their closing statement, but it's the seller's responsibility to provide the title company with their last bill and a current reading of what's left in the property so that the title company can prorate those funds. Next
Perfect.
section is just about title and examination. Obviously, seller shall deliver the abstract or torrents of the property and any information. You know, this is where this section, honestly, we really just rely on our title company to do all of the things that need to be done relative to title. Subdivision of land boundaries and access. If, you know, this is basically just saying if it requires a subdivision of land owned by sellers, sellers shall pay for all expenses. I don't spend a lot of time on this because we don't see this often. And if a subdivision of land needs to take place, I'd prefer to see that done prior to, if I had the seller, prior to going on the market. Mechanics liens. Are you guys familiar with what mechanics liens are?
Yes.
So if the
Yes,
seller
yeah.
hired anybody, you know, like I remodeled my kitchen in 2020. If I wouldn't have paid the contractor, he could have put a lien on my house, which means I wouldn't have been able to sell it until I paid him in full.
Right. Okay.
Okay. Dimensions, buyer acknowledges any dimensions, square footage, etc., are approximate. So this is an interesting thing. I have seen, you know, I've discussed a lot in yesterday's or Tuesday's training. I think we've talked about it before in these trainings that nothing in the MLS is guaranteed, right? And that includes square footage. I've seen buyers get picky about, well, you know, the MLS said it was 2,700 square feet and now the appraisal is coming in at 2,500 square feet. So based on the fact that I'm paying $1.27 per square foot for this property and it's less, people get dialed into that. And it's just a reminder that, hey, the square footage on the MLS is approximate.
Okay, I have questions. Sorry, Cass.
Yeah.
With that. So we just saw a total like crazy property yesterday. It was $96,000. I know this isn't, we're not going anywhere with it, but I'm just curious because the square footage it said was 1 square foot. So yeah, it was like a total tear down. They like
Maybe that's why the agent was doing that.
So then, but pretend that it was still habitable, but barely, and you could like still like renovate it. Would you still have to go and have someone go in to figure out the square footage?
I mean, who's you, the buyer or the seller?
I'm buyer.
I mean, that's up to the buyer whether the amount of square footage is important to them or not.
Okay. But if it's for investing, obviously it would definitely be.
I mean, maybe. I don't feel like people put a lot of, I mean, like my husband and I have been casually looking at houses. Our current house is about 1,700 square feet. If I were to go buy another house, I'd want at least 2,500 square feet to make that move. Would I be pissed if it came back at $24.99? No. You know what I mean? Like, I don't feel like people put that much emphasis on square footage, except people who are very number based.
Okay.
You know, people in those possessions that are really, or professions that are really like number based professions, they're the only ones that seem to get really tied up in this.
Okay.
Access agreement, seller allows to provide reasonable access to the property for the buyer to perform any of their inspections agreed in the contract. It's another interesting one. I've seen sellers after they agree to a purchase agreement start refusing any inspections to the property. And that gets interesting because you can't force them to let you in their home. Okay, risk of loss. Basically, this section is just stating that the home is going to be in the same condition that it was at the time that the buyer looked at the property. So if anything happens, vandalism, flood, earthquake, act of God, property goes up in flames, the buyer is not required to still perform on the contract. Time is of the essence. So it just says time is of the essence in this purchase agreement, which is an interesting one because time of the essence is really subjective, right? Like What's timely to you and what's timely to me could be two different things. Calculation of days. This is something I refer back to often because basically the calculation of days is dependent on whether that section says calendar or business days. And it's always it's following the occurrence of the event specified and includes subsequent days. So back to earlier, I was talking about, we have this listing that was contingent upon the buyer's home selling. They have 3 days to remove that contingency. We called it on Tuesday. So it was like, okay, does day one start Tuesday or Wednesday? Right here, it says after the occurrence of the event specified. So we called it Tuesday, which meant day one was Wednesday. And then you have to determine whether it says business days or calendar days, and business days don't include Saturdays, Sundays, or state or federal holidays. And then calendar days includes all of those things. So like inspection is calendar days. And Chris, we can discuss this one. Like Chris had an inspection that, at the time that she wrote the offer, probably just wasn't looking ahead and thinking about it. It expired on, the inspection period was up Christmas Day. Because
that was an interesting one. I was trying to push my buyers into, I shouldn't say push, but I was trying to encourage my buyers to make decisions sooner rather than later. And it was an older couple and it didn't work. And so I ended up making those negotiations on Christmas Eve or Christmas Day. I don't remember.
Yeah. Yeah. But the point is that the inspection contingency in the purchase agreement states calendar days, not business days. So you have to just, this is a good section to always refer back on. If you're during your inspection or your home sale, you kind of look at that piece. Okay, it says business days or it says calendar days. And then you can come here and you can re-review what business days and calendar days mean. And I know that it sounds self-explanatory, but sometimes I forget, like, business days, does that include holidays or, calendar days? So I actually re-review this quite a bit when I'm helping someone through a situation where we need to really figure out dates. Release of earnest money. Essentially, this is just saying how earnest money can be released, either at the successful closing or with a written agreement between all parties, a cancellation of the purchase agreement signed by both buyer and seller, or under an affidavit or cancellation under Minnesota statute. This is honestly, I'll be honest, I don't know what this specific statute is, but the final one is upon receipt of a court order. Next section is just default and states what the seller is able to do if the buyer defaults this contract for any reason. Predatory offender information. This is on agency. So, the time you get to this purchase agreement shouldn't be the first time that you're visiting that information with your client. Next section just has to do with disclosures on whether it is a property disclosure or a seller's disclosure alternative. You're clicking one of the other boxes. How do you know that? By typically going into supplements to see what's in there. Not always is it in there. So you could leave these boxes blank. And then I put in the other section, seller to provide buyer property disclosures to review within 3 business days of final acceptance of this offer, or whatever time frame you want. In which case then I leave this blank because I don't know what they're providing.
Hey, Cassie, I have a question about disclosures.
Yeah.
So I've had a few instances where the property's been on the market for quite a while, and the disclosure therefore is pretty outdated. Like it might even be a year old. And let's say in a lot of those cases, the property's been vacant for that time. Do you ever want to ask the listing agent to have an updated seller's property disclosure in case there are things that, just because if the sellers aren't coming back, if they're out of state or what have you, and they're not coming back to check on things, that there might be things that are, have gone wrong, like on the property that, maybe you want disclosed. Like for instance, I had one, in fact, the one that you're looking at, the PA here, the heat went out, the refrigerator went out, the freezer went out, and all those things. And then on the disclosures, though, they were so outdated that it said all that stuff was fine.
Yeah, I mean, I would question the seller on that, the seller's agent. It's their responsibility to make sure the most up-to-date information is being provided to the buyer.
Okay.
But if you're seeing something like that, like, hey, you provided me a disclosure that's marked, November of 2022, and I know for a fact some of these items aren't working, we need to get an updated disclosure here.
Yeah. And in fact, in this case, like the disclosure was, I think, from like last April, I want to say. And then the only reason I knew about those things not working was because the listing agent had told me that in a verbal phone conversation. And I'm like, well, then how do I know what to go through here in the seller's disclosure? And a lot of things said that they were just NA. And I'm like, well, what does NA mean when you're talking about like a freezer and those kinds of things? And she goes, oh no, the freezer comes with the house. It's just not working. Oh, okay. Well, interesting.
See,
So
but that's where that agent had her clients fill out that disclosure incorrectly. And this happens all the time in that
yeah, I've
section
noticed that.
that
Good
are
call.
included. Yeah. So what it is check yes or no if the item's working, check NA if it doesn't exist.
Right.
So they filled it out improperly.
Right. Okay, thank you.
Yep. Okay. Next section is about well and septic. So obviously city sewer, city water, you're checking yes or no, and whether they do know of subsurface sewage treatments, if they do know of a well serving the property, and is or is not subject to an addendum to purchase agreement on a well and septic contingency. I feel like this stuff is pretty self-explanatory. However, I've done a lot of well and septics, and I know it feels a little foreign to those who have not. So do you guys have any questions on this section?
No, but I have one little like caveat I'm kind of interested in. So say that it's contingent upon the inspection going through, and some buyers kind of like, oh my gosh, like I hope inspection comes up with something. If you really wanted to protect them and if they wanted to be able to get out at that inspection date, would it help them more to like get like more like a sewage treatment inspection too? So then there's like more things that would have to get like okayed.
Nothing has to be called out in the inspection for a buyer to cancel during their inspection period.
Okay. Huh. So it's literally subjective. Whatever they think could be, whatever comes up, it's subjective. And if they think it's not good, that's period.
Yep.
Okay.
There are some Edina Realty agents that try and fight that. At some point, an attorney at Edina Realty read the contract differently than the rest of the world, if you will. I've seen that go away, but there was a time frame in like 2017, 2018 that all Edina Realty agents would try and fight this. I only bring that up because now with the Edina Realty agents, if a buyer's canceling, whether they have grounds to cancel or not, like they had the grounds for the contract to cancel, but nothing actually came up in the inspection and the buyer just got cold feet, I just tell them, don't even tell the other agent why they're canceling. Here's the cancellation, buyer's not moving forward. You don't have to.
Awesome.
It's found.
Perfect.
What about non-compliant septic? What do you do with something like that? I have somebody looking at a property now that has a non-compliant septic. It just kind of raises a lot of red flags. And I'm not sure what it costs. It's a lot. I know that. We have septic here. We have not had any sort of city situation where they're telling us they're going to put in city sewer and water yet.
Yeah. So non-compliant can be for a variety of different reasons. The septic system could be in perfectly fine working order, but city ordinances regarding that could have changed since the time that the septic was placed on the property 15 years ago, right? Like maybe 15 years ago, the depth of the tank had to be, these are all hypothetical, guys, I don't know the exact, but maybe back then it had to be 6 feet in the ground. And now, the city people decide they want everything 10 feet underground. So now that septic, although it's functioning just fine, is not compliant because it doesn't fit the standards that are now required. Does that make sense? So
that's good. That's good to know.
Non-compliant septic doesn't necessarily mean that the septic's bad. You want to find out the septic compliance certificate is going to be marked whether it's compliant or not. If it's not compliant, it's going to be indicative of why it's not compliant. A non-compliant septic doesn't always need immediate remedy. However, the city could state, like, the current owner's grandfathered in, right? Like, they can keep that septic going for as long as they want, but the city probably has like a caveat in there that says, if you sell this property, the new buyer will have X amount of months or years to replace that to make it compliant.
Yeah, this was a listing that said it had to be, they had a letter in there saying that it was non-compliant and had to be taken care of like within 2 years. And I think,
Yep.
I don't know if a year had already passed or just months had passed. I don't remember.
Yeah. There's a lot that can be surrounding septics. You know, but I don't spend a whole lot of time. Like Chris, you and I run into that more because of where we live. People who service more of downtown areas, you know, Minneapolis, St. Paul, you're not going to run into as many well and septic issues because there's just not as many well and septics there.
Why would 383 be is subject to an addendum?
Oh, because that addendum is stating what inspections are going to be done on the well and septic and who's responsible for paying for them. So a home inspection, the buyer is typically responsible for the cost of that. This addendum to the purchase agreement regarding well and septic, 9 times out of 10, it's that seller is responsible for the inspections and seller's responsible for the payment of them. The reason being is seller only wants to test for this stuff once. If the buyer does the home inspection, the buyer owns the rights to those inspections and doesn't have to release them to the seller. The seller wants a copy of these because the seller is going to be required to provide them to any buyer down the line. So that's typically why well and septic inspections are paid for and provided by the seller. Does that make sense?
Yes,
Yeah.
that does make sense.
So you could require the seller then to get the septic compliant before purchasing that?
Well, I mean, you could certainly put that in the purchase agreement that you're asking them to do it. Doesn't mean the seller will agree.
Yeah.
Making it compliant is different than making them get the testing done on it. So like Chris, to your point, it was in the MLS, that certificate stating it was non-compliant. They already had it tested.
Right.
We know it's non-compliant. They're probably trying to sell it that way and want the buyer to assume it.
That's what I'm thinking as well.
And that always gets tricky. Like for many years, you couldn't have these replaced in the wintertime, right? Because you're digging into the ground. Now they do have the product and the ability to replace septic systems in the middle of winter, but it's ridiculously expensive because the extra equipment that's needed to thaw the ground and replace it.
I've actually had a few listing agents too saying that they weren't going to have any tests performed or the compliance performed until a purchase agreement was submitted.
Yeah,
too, just to say.
The septic is typically good for 2 years.
Mm-hmm.
Well, water testing depends on whether it's FHA or conventional. I wish Colin was still on here now because I think FHA typically likes to see the water testing to be within the last 30 days. And I think conventionals, like, again, 6 months or something. So when I represent sellers, I don't have them do these until the time of a contract either, because what if it takes a little while to sell? And now you paid $600 some for these compliance and well certificates only for them to expire and have to do them all over again. All right. Any other questions on that?
None from me.
Okay. Next section is a home protection warranty plan. I don't know that we need to discuss this in too detail. Either you're checking that the warranty is coming with the property, who it's being paid for by, and who it's to be issued by, or there's no home warranty protection. For a rule of thumb, I generally pick no home protection warranty plan up front. if my buyer's doing a home inspection, because if I'm doing a home inspection, then I use my inspection contingency time frame as an area to negotiate repairs and perhaps a warranty. Whereas if you pick up front that the seller is providing a warranty, they're a lot less willing to negotiate with you on repairs. That being said,
I was wondering, since Jennifer's in this message thing right now, this Zoom, I just want to know why did they actually end up paying for that $1,500 warranty, the sellers?
No,
No,
this deal never went through.
Okay.
But it said in the MLS listing that they were offering 1 year home warranty.
Oh,
that came with it. That's why I included it there.
Yeah. So
Yeah,
yes,
okay, cool.
Jennifer, I didn't mean to say you were silly by doing this. I
Oh
knew
no,
that
I didn't take it that way. I didn't take it that way.
They had offered, so that's why she had done it this way.
Yep.
Also, I will ask for a warranty up front if my buyer is waiving their inspection time frame. Or
yeah, I
waiving-
just figured Jennifer had a good story and it was
Yeah.
good. Yeah.
Yeah, and to answer your question, Alexa, these are typically issued at closing. So
Okay.
a buyer or seller is not paying for it until that time frame anyways.
Okay.
All right, next section is just who's representing who in the transaction. Next section is if dual agency does or does not apply.
Okay, I actually do have a question on dual agency too right now, because I know we're supposed to be just like fiduciary, like or not fiduciaries. What is it called? When you're just like people
Fiduciary? Or
what is that? Is it fiduciaries? Facilitators. So like you can't like go for one side of the transaction or the other if it's dual agency. And I'm wondering how that actually like plays a role in how you recommend like paths moving forward for if you're like representing the buyer. Like, do you take your recommendations out of it? Because that would be
yes,
not in the best interest for the seller.
Dual agency is different than a facilitator. A facilitator provides no representation to either party. A prime example of that is my neighbor, and this is a true story. My neighbor rented for several years before he bought the house that he's living in. Okay. My neighbor's an auto mechanic. The owner of that home was a police officer. The police officer said, I don't want to be a landlord anymore. And my neighbor was like, cool. I don't want to be a renter anymore. I'd like to buy the house. Police officer was like, sweet. What do you want to buy it for? Here's what I want for it. And the neighbor's like, I'm willing to pay for that. They approached me and had everything negotiated out already. And I simply drafted the paperwork for them. I wasn't providing representation to either party on what they should pay, what they should ask for, what they should negotiate. They had all of those terms come to agreement before coming to me. And I simply drafted the terms that they had already come to agreement on. So facilitator provides no representation. Whereas in dual agency, you're still providing them representation, but you represent both parties, so you cannot negotiate for the benefit or detriment of either party. And what that looks like, if I represent seller and I get an offer in, that would be dual agency. And let's say the property is listed at $250 and their pre-approval letter says they qualify for up to $275. If it wasn't dual agency, I'd be pointing that out to my sellers. Hey, they only offered us $255, but we know that they qualified for $275. Let's counter them. I would not be able to say that in a dual agency transaction because that is a detriment to the buyer by pointing that out.
Oh,
That
okay.
sense? So
yeah, that does.
You're keeping confidential information between them. I mean, this does say that we're working diligently to facilitate the mechanics of the sale, but you're still providing them representation. You know, it is kind of borderline a facilitator because you can't tell them what they should offer. Technically, if it's dual agency, you shouldn't even be running comps for the buyer to provide them.
Ooh, okay.
To take this a step further, when you're filling out feedback in showing time on a dual agency property, you shouldn't be like commenting anything about price being too high, too low, etc., because you already represent the seller.
Okay.
So it does get tricky, but like I explain to people when I am in a dual agency situation is I'm going to provide you all of the information and you have to make a choice. So a dual agency I had a few years ago, I represented both the buyer and the seller. there was a Federal Pacific. I've had quite a few of these. If you guys, anyhow, had Federal Pacific electrical panel, which are not good. They oftentimes started fires. So it is recommended that they be replaced. That came up on the inspection. I went to the seller. Hey, there's a Federal Pacific panel here. Buyers would like it replaced. Seller said, okay, I'll replace it. So I was just kind of really going between the two and providing the information. So I wasn't able to maybe say to my seller, hey, maybe you counter back at the buyer asking him to split it 50-50. I couldn't say that. I had to say, this needs to be replaced. They would like it replaced. How would you like to respond?
Okay. That makes sense.
All right. I'm gonna cut us off now because it's 11. So next week we'll finish the last few, and then we'll take some time to go through some different addendums and amendments.
Okay. Sorry about all the questions, everyone. I like to be involved.
That's what this is for.
Okay. Sounds good. Thank you all,
right.
everyone.
Bye, everyone.
Thank you.
Yep.